Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our speaker. So if you have a question, please type it into the comments section below, and we will be sure to address it. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today, we have Stacey Cutting with us to talk about the Undergraduate Mediation College. Stacey practices personal injury law in Los Angeles at Bish and Cutting. That first name might sound familiar, as it is the last name of our very own Mindy Bish, with whom Stacey has worked for many years. Stacey's also KTI faculty, of course, teaching mediation and probably a handful of other courses, as we all do. As always, we'll put her contact information in the description below so that you can contact her with any questions you have about this college or anything else Edge. All right, Stacey, this college was one of my personal favorites. So tell us all about it and what we can expect when we attend.
All right, Jenna, thank you so much for that great introduction.
You're welcome.
And mediation was actually one of my favorite courses as well. And you're correct. I have been trained to teach many courses, but by far this one is one of my favorites to teach because it's really, I think, a game changer for many attorneys because we don't try cases every day, but we mediate cases quite frequently. And if you're anything like I was, when I first came to the college, I was very frustrated with the mediation process. I always felt like it was completely out of control, like we really had no say. It always felt like we showed up, they dumped on our case and offered pennies and said, take it or leave it. And it was very, very hard to swallow and very frustrating. I don't know if you had any similar experiences to mediation before you took the college.
Yeah, I feel like sometimes I still have it, even if we prepare correctly, but it's definitely much less since we've learned how to prepare for mediation. I mean, it's when you prepare for mediation, the way Edge teaches, it's almost like you're preparing for kind of a trial, sort of. It's a lot of work that goes into it.
100%. When I was thinking about what we would talk about today, the first thing that jumped out in my mind was the concept of control, which we cover extensively in the course, right? Mm-hmm. So pretty much everything we do in the Edge has to do with control and certainty. And that starts at the very, very beginning. We control essentially our destiny by making sure our incoming cases or the cases we take meet the case selection criteria, right?
Mm-hmm. Absolutely.
We got to look at what did the defendant do? Why should the community care? What's the system failure? We've all had event cases. We've probably all lost event cases. What we learn in the Edge, right, is that if the jury doesn't have some sort of personal stake invested in the case or the outcome or preventing a reoccurring danger, then it never goes well for us.
Mm-hmm. Yep.
And so our control really starts at the very beginning when we first select our case and decide if we're going to take it or not. We also are taught that we control our own destiny by the amount of work we put in to our cases. Right, the Edge is not a magic trick. You don't just get miraculous results because you do a few things. It is a system that requires a lot of work from start to finish. And really, it starts at the very beginning by just outworking the other side in discovery. We control our case by doing a very good and thorough witness preparation, right? And properly arming our client with their major truths and why they're here, right? Is to make sure that this doesn't ever happen to anyone else ever again. We also control our case through, developing our system failure and that narrative through the depositions of the defense witnesses, right? And so, and two, we also control our case by knowing more than our own expert witnesses do, right? And educating them on the system failure and how we try these cases. And so if we, do all of those things, then presumably then at the end of that, you're ready to mediate, right?
Yes, hopefully. And hopefully you have a willing defendant and everything else and everything goes your way. But that's the setup. It's so important, that setup, all of that work, because it's when you just show up at mediation and are like, that's when you're out of control and it ends up, very frustrating, right?
Right. Spiraling out of control, right? If you're not in control, they're in control. There's no nobody's in control. If you don't have control, they got it. And that's when you run into trouble. And I would just like to, mention, side note here, right? Part of getting cases resolved also depends on whether or not we actually try cases, right? We're trial lawyers. If you are a trial coward, you are in the wrong business. And what I've learned is it does not even matter if you win or lose the trial. What matters is your reputation, right? And whether or not the other side knows that you're willing to go to trial. I actually just took a phone call yesterday, a defendant begging me to go to mediation because we are always like, no. He had been emailing me. I just didn't even respond. So he got me on the phone yesterday and he said, look, we want to go to mediation. And I said, well, I don't know if it's really going to be productive. I don't. And he said, look, I know you try cases. He goes, he was laughing. He goes, actually, I'm a little afraid of you because I know you will try the case. I said, I will. I said, I will try the case. Yeah. And he said, and this is true on the down low, right? Just chatting. He said, I do look at the attorney who's handling any case. He goes, and there are certain attorneys out there, they're never going to try the case. And so if they know you're never going to try the case, your offer is going to be what your offer is going to be, take it or leave it, because there's no risk for them in that.
Right.
So there is a lot of benefit or play to trying cases and them knowing, win, lose, or draw, they'll go in there and they'll take the fight to us. So, it's just super important that you try cases. It doesn't have to be a ton, but they have to know that you're willing to do it.
Yeah. And that's the thing too about control and mediation setting is that as you say, they come with a certain amount or whatever. And the control is yours when you can get up and walk away if that amount is not enough. And know that, yes, okay, fine, you came with this amount, I get it, we're leaving, and we're going to go spend our time preparing for trial. Instead of, at the end of the day, you're like, oh no, this is all they came for, but I don't do trials, so That's all I'm getting, right?
Yeah, 100%. And, and obviously the course talks a lot about, your reputation, mean what you say what you mean. We have to be consistent. We cannot go in there and say, we want X number of dollars. This is it. The line is drawn in the sand and then turn around and say, a month later, 2 months later, okay, we'll take the peanuts you're offering because they take note of that as well, right?
Absolutely. Yeah.
So
Sometimes it's hard to stick to your number. You might learn something, hopefully, right? If you've done the work, you know what your number is and you don't have to worry about it. But, things happen and it can be hard to stick to that number, but you really have to. And that's why it's important to get in. And one thing that we talk about in the mediation college is how to find a number and where to, how to do it. But it's important that that is a well-researched and reasonable, based on evidence and focus groups and everything else, so that, what you can draw that line in the sand and then go try it and, not have to worry too much, or at least know that, I stood up for what I truly believe this case is worth.
yeah, and you mentioned, and because Don wrote that blog last week, so I figured we could talk about the blog that he wrote last week on settlement value. But, you mentioned it, sometimes it's hard to stick to your number. And I will say this, it can be. And time is not our friend. So a word out there to whoever may be listening, right? There's a reason Mr. Keenan is constantly telling us, don't continue your cases. You want to be out in front of this. You want to prosecute this, because as time goes on, things happen and things change. And in my experience is it's usually not in my favor. So I'm sure all of you out, COVID for us put a 2-year delay in everything. And so now I've got, clients where maybe they had a surgical recommendation 2.5 years ago, and maybe they don't really want the surgery, but I can take that to trial and say, 6 months ago, they were recommended the surgery and she's going to get it. It is a lot harder pitch to make when they still haven't gotten the surgery and it's now 2.5 years later, because they're going to look at me and the jury is going to look at me and say, she hasn't gotten it yet. She's not getting it. Right.
Yeah.
And so that is where things can definitely change. And I don't think anyone could have anticipated something like COVID. Right. But it's here, and I'm having to deal with it in my practice right now. And so some reevaluation is having to be done on my part on those particular cases. But so just a reminder to everybody that it is, good to stay on top of your cases, stay ahead of them, get them litigated as quickly as possible, so that way you don't run into problems later on.
Mm-hmm. Yep.
And
your clients getting older, your clients maybe dying, your clients getting miraculously getting perfectly better.
Yeah.
All these things, it just changes everything. And so all the work that you do just becomes less impactful. And that's frustrating. And that's great for the defense, man. Defense, at least up here, because our courts are very, at least in state court, I don't remember if they're in federal court. I'm not in federal court as often, but they're very strict about trial schedules. You file and your trial date is 1 year from that date. And that is when you are going to trial. And usually there's maybe one continuance for maybe 6 months. So within 18 months, your case is tried, but for, of course, COVID and things like that. But defense is always asking for a continuance. And, for folks who are listening or considering this point about time is not your friend and keep on top of your cases, why are they asking for it? Right? That means they need it. That means that getting your case to trial on time is a bad thing for them. Therefore, it's a good thing for you. So make sure you do it. Make sure you get there on time or as quickly as possible.
Right. Yeah. I mean, it's really important. And I don't know about you, but I can tell you that the clients that I have whose cases were ready to go right before COVID that have been now kicked around for the last 2.5 years, they're pissed off. Like you want happy clients, get their cases done and resolved as soon as possible if you can. Like they're angry and they're telling me, look, I know it's not your fault, but this has just been going on forever and I'm so frustrated. And I said, I get it. So happy clients, better results, the quicker we can get things done.
Just get through it.
right?
Yeah.
Do the work and get it done.
Mm-hmm.
And so one of the things we also touch on mediation college is, you need to know if your case is a case that you can try or if it's a case that has to settle, because that is going to kind of shape your approach to settlement in the mediation process. For those of you that don't know, the way you find out whether or not you can try your case is you have to focus group it, right? We all obviously think our cases are great. If we didn't think they were great, we wouldn't have taken them in the first place. But really, it's through that focus grouping process that we realize whether or not we can actually take a case to trial. So what comes to mind is, and I had a blog written up about it, right? So Mindy and I got a $4.2 million settlement on a brain injury case involving a motorcycle rider. But the key point there was that we 100% knew we were never going to try that case. We had done focus groups. He was a young man at the time of the collision, maybe 21, 22 years old. He did not have a motorcycle endorsement on his license, right? So he hadn't gone through any sort of classes, education, or training on motorcycle riding. He was riding, crotch rocket, right? The worst kind of motorcycle you can have in your case. His helmet flew off upon impact. So there was, the notion that he didn't properly strap on his helmet even before getting on the bike. And then we had eyewitness testimony that, he was driving like a bat out of hell. It looked like he had a death wish. I mean, just, you name it, it was. And so the amount of comparative on our client was astronomical. And so you wonder how on earth do you get $4.2 million on a case like that, right? The prior attorney that had the file, the top offer was $300,000 with an indication that, maybe they might go higher. And I think the prior attorney was like, let's just get $1 million and be done with it. But the young man had a legitimate brain injury and he was going to have to deal with this for the rest of his life. And so how do you get from $300,000 to $4.2 million? When we took over, we jumped in, we started doing a lot of work. Now, this case was ready to go to trial in like 90 days. So we immediately started filing motions and creating a lot of extra work for the other side. And we really needed a continuance, right?
Yeah, but
because of what the prior attorney had done. But what we did was we made it so difficult for them that they were asking us for the continuance. And then we said, okay, all right, you do X, Y, and Z, and we'll agree to the continuance. And again, that goes back to the control, right? I'm going to make work for you. And then you're going to come to me and ask for more time. And then I'm going to slap down some conditions on you. Okay. Yeah, maybe we can agree to that if you're willing to do this. And so, we took some depositions, we got all the experts in line, and we got on the adjuster immediately, started calling him and telling him the prior attorney completely misevaluated this case. The demand's now $8 million. I don't know what you think was going on before. And so really, we stuck to $8 million all the way up until I think, maybe 30 days before trial. And, I spoke with her. We sent letters. We just started pounding them. We also had two defense attorneys. One had the underlying policy that had already tendered it, right? So she was... and they were having her, for some reason, do all the work. the one who had the underlying policy that had tendered, she was going to be primary trial counsel, and she was the one that was having to do all the work for the excess. And so we kind of made her our friend, right? And we used her to help us. Now, what we did tell her was constantly her to the defense attorney, we're going to try this case and you're going to get your ass kicked. And she was like, I know. That's what she told me. I know you're going to try this case.
She's like, that's why I gave you my limits. I gave you everything I can. Yeah. It's not my fault.
Yeah, I know I'm going to get my clock cleaned by you at trial. I know this is a serious case. Everybody agrees he's got a brain injury. I don't know what the excess is doing. And so we really, again, control over the defense attorney. So we started to assert control over the adjuster, control over the defense attorney. Once we decided the case was ready for mediation, we showed up. We had our PowerPoint presentation ready to go. I told the mediator, you can let the other side know we want them to come watch it. If they refuse, I'm going to show it to you and you're not going to be able to tell them anything that's in it. Right. So there's the dangling carrot, because we don't have in California, and I know every jurisdiction's different, we don't really have joint session mediations. Do you guys have joint session mediations up there where you're at?
It depends. And when we have the pre-mediation conversation with the mediator, we always say we are bringing something and we'd like the opportunity to do a joint session and show it. I find that it's best to address it ahead of time, because when we sprung it on them during mediation, some mediators pushed back and said, I don't, they were like, I don't do this. And yeah. I don't know, but we can't. I will say trying to think, we've only done Zoom mediations since we've been doing, I'm trying to think. Yeah, I think even with our RA case with Dawn, it was a Zoom mediation. So all the times that we've done like this full edge mediation has been on Zoom. So they just throw us in a room together and, we show it. But yeah.
Yeah, and so we pulled them in. I had my PowerPoint presentation. Of course, it started with what the defendant did and the system failure, and then we moved through the injuries and what we had in there that they had never seen before. And with brain injury cases, the most impactful witnesses are the before and afters, right? So. And in this particular case, his brain injury was not really in dispute. Everybody agreed. But we had gone and taken a video of a gentleman he worked with at Chipotle before the collision. He was eventually able to return back to work at Chipotle. And so, of course, their theory is always like, oh, he worked at Chipotle before, he's there now, he's fine. Right. And so what this manager was able to do is not only talk about the complete personality change, but he explained that this guy was on a management track for Chipotle. And then when he came back, he had difficulty even doing the routine, repetitive burrito making tasks, right, after this injury. And, and so we showed it to him. It did not resolve at the mediation. They did not bring enough money. But what happened after that was, again, I went back to my defense attorney and we were talking about the mediation. And she did say this. She said, Stacey, you should do that at all your mediations. I said, really? Mm. She said, yeah. She goes, it completely changed the conversation in that room. It completely changed the way those adjusters were looking at this case. And, and so as we drove up to trial, eventually we had gotten them up to, I think, $3.6 million. At that point, the client was like, let's just take it. they had served what we call a statutory offer to compromise in 998 for $3.6 million. It was not going to expire until the day of trial. We had the client's authority to take it up to trial to try and get more. And, and so what we had doing, and this goes back to control and what you say and not caving, right? We always knew we were going to take the $3.6 million at the end of the day if we had to. But our mantra to them at the end had finally been 4.2 is the real number. You need to pay 4.2 to get out of this case. And they said they understood. And in typical defendant fashion, they served a statutory offer to compromise for 3.6. That's what I called them. I said, we told you the number was 4.2. You told me you understood that. Like, what is going on? And she's like, I know. And so I said, look, we're going to try this case. And, literally trial was supposed to start Monday. They paid the 4.2 on Friday. And so part of the reason they paid the money was because we talk about control and certainty. We had given them certainty that we were going to try that case if they did not pay that money. And again, that goes back to what we discussed earlier, like you have to try cases, you have to be a trial attorney. You cannot give them any sort of certainty. This is the real number. We're going to trial if you don't pay this number, if you don't try cases. And so that's why, again, you're given a whole system in the mediation college, and you have to, kind of check all the boxes on each part of the system. Otherwise, it just doesn't work.
Right.
It does not work. And so, and just because we're going to start talking about settlement value and Dawn's blog in just a minute, but I think it's hard to remember now, but I think our Buffett paradigm number was somewhere in the $2 million range. So again, we got, and it might have even been 1.5, but it was somewhere between 1.5 and $2.5 million. But either way, another note that you don't stop just because you've met your number, right? Mm-hmm. I've always looked at the Buffett number is kind of like the floor. It is not the ceiling. Mm-hmm. That number is the number. If they don't pay this number, we're going to trial. So we had obviously met and exceeded our Buffett number and, just rode it all the way to trial to maximize value and get every last penny we could out of the other side. Mm-hmm. And we certainly couldn't have done all of that if we hadn't have done the work. We weren't prepared and we were not in control of our own case. And so Dawn wrote a great blog last week about determining settlement value. And he listed, I think, about 5 or 6, maybe 7 things in that blog, about how we determine value on our cases. The first thing he mentioned was focus grouping. You focus group your cases, right, Jenna?
Many, many times on all of our cases.
Yes. And so, Dawn has always said that focus groups are useless when it comes to value. They look at it like play money, and he said that in the blog last week. But what he told us is focus groups can tell you what damages your client have are important to them, the ones we should focus on, right? So if you've got a client with many injuries and you need to focus on what's most important, you use a focus group for that. And I think you've done it. I know our office does it. Another way to determine settlement value is you get a life care plan, right? And you focus group that life care plan. Yeah. Have you and your partner done that before? Focus group, your life care plans?
And I really, really encourage people to do this because at least up here, well, I should say in the last case we tried, the defense really got into the purpose and the philosophy behind life care plans. And it was interesting because they went straight at it as you're just bringing this in here to pump up your numbers. And that's the whole cross was about that. There's like a book out there apparently that was written on it in the 80s, and they were reading excerpts from it. And so if you don't have a rock solid life care plan that you already know from doing focus groups that people believe, every item, like put the items up there, not just say our life care plan is worth X dollars, but it could really, really cause a problem. It was effective in this past case that they were doing that, and the jury questioned a previously unquestioned life care plan. And so highly recommend putting actually the life care plan in front of a focus group for sure.
Yes. And so, you basically put the life care plan up there and you go through it line by line. Do they need this? Is this important? What do you think about the prices? High, low, which price would you go with, right? And really by going through those questions with them, they tell you if they think some proposed treatment is bullshit, they tell you. If they think something's important, they tell you. If they think the prices are too low or too high, they tell you. And then that way you can walk into trial knowing this is what they care about. And if you think about it for mediation purposes, right? If they want to attack your life care plan or any portion of your treatment plan, you have those clips that you can bust out and overcome those objections, right? You say that. You say this is not important, but we've talked to a lot of people and they disagree, and this is what they have to say about it. Super effective, not coming from you, coming from real people. And that is part of mediating a case too, right? Trying to anticipate what they think their greatest strengths are, right? And it's our job to swift boat those and have responses at mediation to the things that they're going to say to try and, get us to come down off of our number.
Yep.
And
one of the things that I really liked about the mediation college was learning that you can use mediation to get information. I mean, say it's a bust by like the first couple hours, that it's not going to go anywhere. You can find out their defenses.
Yeah.
If you didn't, if you weren't certain before what they were going to be, you can find out their defenses, the best evidence they believe they have, blah, 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 lots of stuff just by sticking around.
Yeah, 100%. And, we do teach at the mediation college that they only get one mediation. We only agree to one mediation, but I think subsequent blogs have been written about it. And we've actually, on cases we co-counseled with Dawn, there are cases, big cases, where there's going to have to be two, right? One's kind of like a fact-finding mission. The first one where you go in and maybe find out what their defenses are and really to educate the other side about you and your case. Sometimes they're just not educated enough. And if it's a real big case involving big numbers, quite often they're not going to have everything they need to pay at that first mediation. So there are cases where there's going to be two, and you just, if you have one of those cases where it probably cannot get done in the first mediation, then you don't make it. We have not talked about mediation conditions letters, right? So when they're asking for mediation, like the other attorney asked me yesterday, you're going to want to impose certain conditions before you agree to go to mediation. Now, on the smaller cases, one of the conditions perfectly acceptable to say, we're only doing this one time. You get one shot at mediation. If we can't get it resolved, it's trial. If you've got a big case where you know you're probably going to need more than one, then don't make that one of your conditions, right?
Right.
Because again, we want to have integrity. Our word needs to be good, and so you can't say one mediation and then have a case where you obviously need to, and then you agree to go to a second one. It does not exude a bunch of control or certainty on your part. But definitely mediations can be a great tool to go in and get information. So on the trial you mentioned about the life care plan, it's interesting because I've actually never heard of that or had that come up. Did you mediate this case? Was this something that was brought up at mediation as well, or is this something they saved for trial?
It was, I want to say, it was not brought up at mediation. That's the short answer. So I didn't know about this, but I did find out about it through some way before trial. And so I had told our expert about it. I was like, they're going to come at you with this. And so he was like aware, and he was able to give a pretty good answer. There were some other issues. He kind of lacked some confidence and that kind of thing. And so I think when he gave his answer, it sounded a little bit wishy-washy. And I was like, oh, geez, dude, you have to really come out of the gate when they're attacking your integrity like that and saying you just did this to pump up the numbers. It's artificial. It's inflated. You have to be real confident about your response to that. Otherwise, the jury's like, I don't know about this guy.
Yeah.
So there was other issues there, but yeah, I think it was really interesting, and I hate saying that it was effective, but it really, I don't know, had they not done it, or had we had it, there's no way to know what would have turned it around necessarily, but it was certainly a better way of going about it, because they had no expert to defend against the life care plan. So all they could do was attack it.
Yeah. All right. Yeah. Always, my husband tells me we're either making money or we're learning lessons.
That is so true. God. It's very true. Yep.
So, so as far as settlement value goes, you mentioned going to the verdicts and settlement databases. That is another way to try and calculate the value of a case. Do you do that on every case you have?
Every case. We have a great little company called Jury Verdicts Northwest up here. I want to give them a shout out. Melissa McCann over there is awesome. And for like $175, they'll pull the last 5, 10, however many years you want of cases. And they also will search out, they go through the court system, I'm assuming, and they'll send you an email and say, hey, I saw you had this verdict, or hey, I saw you had this case. What was the outcome? And just like elicit information from us. Like after my last case, I got an email from Melissa and she's like, hey, we want the info of this case so that it can go into that database. I haven't given it to her yet because I'm still processing what happened in that case, but I'm going to, because it's so important. But a really good example of this is just a couple weeks ago on an employment case. I was like, can you give me, Washington law against discrimination verdicts, whatever. They were all but maybe 5 defense verdicts. And I was like, oh, wow, this is really interesting. And this is in the past 7 years. And so definitely a piece of information to consider about when we make that decision. We're pre-filing now, but that's another really good place to go to see what the jurors' sentiments are in your community about certain issues, kind of, right? And maybe those lawyers tried terrible cases. I don't know, but that's rare. We have that many defense verdicts. I'm like, plaintiff demanded 1.2 million defense verdict. Plaintiff demanded 300,000 defense verdict. And I was like, oh, good Lord. So that's a good one.
Yeah. And so obviously, Dawn mentioned in the article, LexisNexis, you can run verdicts and settlements through Lexis. There's also services in each community that you can go to get this information. I know for years, Dawn has kept a EDGE verdicts and settlement database. You can always reach out to either William or Clint, or, to find out how you can access that. And so you get the numbers and you look at, what are other cases out there like this one settling for, or, what sort of verdicts are out there that you're getting. It's another way to at least get a handle on what the value of your case may be. Dawn also mentioned, obviously, talking to a seasoned mediator. We've all, I don't know about your community, but where I am, you hear the same mediators tossed out over and over and over again. So that these people see your case or something like your case all the time. Whereas we might only have, had 1 or 2 or 3 employment cases in the past. There's mediators out there that have seen thousands that know, as a general rule, what your type of case is going to settle for. So never, and I don't know about you, but our mediators always like return business, repeat clients, right? They're usually more than happy to take your call. I'm sure they won't hesitate to have a 5 or 10 minute chat with you about your questions. And, if you think about it, right, nobody really asks the mediator, what's going on with them.
Yeah.
Any good stuff come across your desk lately? And, it goes back, Dawn always talks about how to win friends and influence people. It's just another way too. I think you can really make your mediator feel important and want to help you. So definitely a resource, for sure, underutilized resource out there available to us. You don't have to be in the dark. There's no reason to be in the dark.
Right.
And Dawn, I know, has used in the past quite often an insurance insider to give them some inside information about how they approach settlement. That is something I personally have not ever done yet. Have you ever used an insurance insider yet, Jenna?
I haven't. I don't think I've had, here's my dog. Hello. I haven't had enough cases with the same adjuster, or to develop a relationship. I shouldn't say that anybody necessarily does have that, but, I haven't really developed a relationship with anybody like that. I'm not really sure how to. Dawn is so good at having relationships with people and developing things. I'm like, not.
He makes them feel important, right?
Yeah, he does.
He gets them to want to help him. He does. He's very gifted and talented at that.
Yeah.
Hands down.
Yep.
He's a magician.
It is.
And so the next way to determine settlement value is the Buffett paradigm. And so I was surprised to see it in a blog, because
I wondered about that. I thought, oh, that's interesting.
Yeah. So for years and years, that has been top secret sauce. You learned it at the mediation college, only you were not allowed to share it with other people that had not been to the mediation college. So for me, in taking the mediation course and in teaching this particular concept has been really earth-shattering for a lot of attorneys. I know it was for me. And for us, this is really where our drop dead number, pay this or we're going to trial, comes from, is that doing that Buffett paradigm. And you do take the verdicts and settlements, you throw out the super high, you throw out the super low, you get a worst day at trial number, a best day at trial number, an average day at trial number, and, average those out. And that becomes your Buffett paradigm number, and you want to have other seasoned attorneys who try cases do one as well. So that way you can look at them and, and look at the numbers. If they're close, that's your number. And if they're not close, you just need to do a little more work to see where you're at. And this Buffett paradigm number is what can give us certainty about our number. A few years ago, I had a case where a woman had had shoulder surgery. Our Buffett paradigm number was $28,000. And you think, how can your number be $28,000 for a shoulder surgery case? Well, it was a no visible property damage case. And she was actually in an access van. So there was an interior camera that recorded the collision. And it didn't even look like she moved. Like it looked like she had gone over a speed bump, right? And I mean, it was so bad, the defense attorney was like, you should just dismiss your case, right?
You should just quit now.
Mm-hmm. Yeah. So when you factored in the low verdict and the defense verdict, that's how you end up with $28,000 for a shoulder surgery, right? But her case really did have some merit, and she had some prior pre-existing issues. She was in a van for the disabled, and so our number was $28,000. They came up to 25, and I said, no, you got to pay $28,000, or we're going to try this case. And he wouldn't pay the extra $3,000, and we tried the case, and wouldn't you know, I got $100,000 on that case.
Awesome! That's so cool. I love that.
Yeah, but so it is. And had they paid the $28,000, we would have taken the $28,000, and actually the client would have been okay with it. But because I had explained to her the risks, right? The real risks of proceeding to trial. And because I had the Buffett number, I walked into that courtroom with some confidence, like, guess what? I might lose, but I'm not taking the shit that they offer me and just rolling it over, right? And that was the result. And it tickled me to death because it was worth $100,000. Mm-hmm. Right? You never know what kind of jury you're going to get, or if they're going to see it the same way. But through Dawn's great jury selection questions and really getting to some of those issues in jury selection, you can get those results. So you have to have a number. You have to know if they don't meet that number, we're going to try this case. Mm-hmm. And then at the end of the article, he basically says, determining settlement value, use a combination of the above. So,
so freaking hard. I feel like it's like the hardest thing to figure out. Cause I don't know, sometimes you'll do a Buffett and you'll get people who just really believe in you and they think you can get these crazy verdicts. And I'm like, or I don't know. So it's really hard, but it really is a practice, part of your practice that you have to practice, say practice again, because you get better at figuring out who is somebody you want to ask to help you with it. You get better at kind of assessing the facts and what your realistic ability is based on those facts and getting a settlement or getting a verdict, because that's so important to consider. You get better at it, I think, over time. So we're still working on it, but it's hard to figure out. But like you say, with the certainty thing, it is really nice. I will always tell the mediator, if that's all they have, I would rather a jury tell me that my case is worth that much than to take it from them.
Yeah.
Because it might be painful and it might not be fun for a jury to tell you that, but at least that's what the community thinks. And it's not some insurance adjuster or defense attorney, black hat or whatever, saying your case is crap, because I'm not going to buy that,
Yeah, well, and really, because we talk about exercising, control over the client at mediation, right? And getting the client on board with that number. And, how good is your client going to feel when you look at them and say, I will spend the time and I will spend the money to try your case because I believe in you. And guess what? A jury may agree with the defense, but we're going to go there and we're going to see what they say.
Absolutely.
I know the tough cases that I've taken to trial that, we may not have been successful, or we may not have been as successful as we would have liked to have been. My clients are always grateful, super grateful, because they know, like, I fought for them, right?
Mm-hmm.
Isn't that what we do? Isn't that what we're supposed to do? We're supposed to fight for those people that have been injured, right? Because of some system failure. And it's our job to try and go in and educate the community about the danger being presented, and, really let that client have his or her day in court.
Mm-hmm. Yep, absolutely. With the last few minutes, Stacey, will you tell us what we can expect to have, like what tools, and without doing secret sauce stuff, when we go through the mediation college?
So I think for a lot of people, it is a completely different philosophy and a completely different approach. If you are a newer attorney, take the course right now.
Yes, I agree.
Don't get into any bad habits. Just like do this stuff, and from the gate. If you have been practicing a while, I think what you'll get from it is a solution to the things that have plagued you and the problems that have bothered you over the years about mediation. And I'll say this because every time you teach a course, and it doesn't really matter what the subject is, whether it be openings or jury selection or depositions, you always get the response, well, that won't work in my jurisdiction, or that won't work for me. And the truth is it won't work if you don't try it. Like, you have to try this stuff, and you have to keep trying it. And once you keep working at it, you will find what works and what doesn't. You can kind of make things your own, but 100%, what you're going to get is a way to approach things to do to get cases into hopefully a more successful mediation. And guess what? Sometimes maybe the success is just learning to say, we're done here. Mm-hmm. The answer is no. You've offended us and we're done here. We're going to try this case.
Mm-hmm. Yep. We just had to do that on Tuesday. In King County, unfortunately, mediation is required. So condition letters are kind of out the window. We have to go. Yeah. Of course, get we tried filing motions to get out of it. Mm-hmm. But courts believe that mediation will beat down the plaintiff and, get us to settle. So anyways, it's required. And one of the defendants came with like $2,000, I think was their top offer. And so we stuck around and tried to get as much information as we could out of it. We figured we'd use our time. We'd already paid for the mediator. But we left, and we made sure that we were the ones to leave. Yep. Right. Because the mediator was like, oh, should I dismiss the state? And I was like, no. We will leave, and you can go tell them that we left, but I don't want you to say, oh, you get to leave, as a reward for coming with no money. That's another thing with the control thing. We are leaving. You can tell them we left because their offer was offensive. Bye. Yeah.
Yeah. And sometimes too, with the court ordered ones where you have to go and you don't have a choice, what I'll do is I send a letter ahead of time. Like these are our expectations. This is what, and we're going to leave. if you don't bring any money and you offend us, just know we're leaving. Mm-hmm. Yep. Put it out there ahead of time just so they know exactly what's coming.
Yep. And then do it.
And then, yes, you have to do it. That's the important part.
Yep. Even if it's like, oh, they're so close, maybe no, you know what? They didn't get there. Go leave. And then you know what? Maybe they will. In our case, it will not. We will go to trial. But in some cases, they call you later, or the mediator calls up and says, hey, they called me and wanted me to share this with you or that with you. And maybe you do get there. In our referring attorney case with Dawn, that's what happened. It did not settle on mediation. It settled like 30 days before trial, I think.
Yeah.
So yeah, mediation doesn't end when you sign off of Zoom or walk out of the mediator's office.
No. In fact, and you just got to keep being the woodpecker, right? The $4.2 million, the mediation ended. We immediately started serving trial documents, right? Jury instructions, motions in limine. And we did the Chinese water drip, right? We just started peppering them with something every other day or every third day. Just here you go, here you go, here you go.
Mm-hmm. That's right. Yep. Just keep working it and it will work. It will work if you work it.
It will.
Yep. Awesome. Thank you so much, Stacey, for being here this afternoon with us. And thank you to all of you who joined us live for this week's episode of Keenan's Cutting Edge. If you liked today's episode, please click that thumbs up and don't forget to subscribe and sign up for alerts so that you don't miss an episode. Next week, we have Dino Tangretti with us out of Massachusetts. Dino is going to be talking to us about a trial result where he successfully obtained justice for his client using edge techniques. I look forward to hearing the juicy details along with all of you. Have a wonderful weekend, and I will see you next time.